The next thing on the agenda is the Hatch Act. Speaker will be Ms. Anna Galino Marone, Chief Hatch Act Unit, U.S. Special Office of Special Counsel. She began her employment at the Office of Special Counsel in 1998, and in 1999 she joined the Prosecution Division. She has been the Chief of the Hatch Act since 2000. Join me in welcoming her.
Thank you for being here with us.
Good morning. My name is Anna Galindo Marone, and I'm, as I was introduced, I'm the Chief of the Hatch Act Unit at the Office of Special Counsel. The Office of Special Counsel is the only agency responsible for enforcement of the Hatch Act. And I want to begin by saying thank you for inviting me to speak to you all about the Hatch Act. This is a pretty timely period to be having this discussion. We've been seeing an uptick in the number of cases coming in involving state and local employees, in particular law enforcement officials. So you will see that a lot of the examples that I'm going to be using are particular to either police departments or sheriff's offices. I encourage you all to ask questions during the presentation. I usually learn from your questions and sort of modify the presentation based on what's on your mind and the types of questions that you have. So in terms of the Hatch Act and who it applies to, it covers all government employees for the federal that are in the federal government. So if you're a federal employee, everyone's covered. If you're a state and local employee, only certain employees are covered. And as I move through the slides, I'll break it out for you in terms of how the Hatch Act applies to state and local officials. In terms of the purpose of the Hatch Act, and where is the clicker? I'm sorry. This looks very different. Oops. There we go. Thank you. In terms of the purpose of the Hatch Act was passed in 1939. At first, it only applied to federal employees. Then in 1940, it was extended to state and local employees. Then in 2012, there was a significant amendment to the Hatch Act that reduced the number of state and local employees that were subject to the candidacy prohibition. That's had a significant impact, I think, in terms of state and local employees that can now run for office. It's also had an impact in terms of our office. Half of our business used to be state and local business. And since the reforms in 2012, we've seen a significant drop in the number of cases involving state and local employees. But the cases we do get tend to be the serious cases involving coercion. So we basically have lost the candidacy business, but what remains are the cases involving political coercion that I'll speak to at length. So what the Reauthorization Act did, it sort of created a two-tier approach to coverage. Oops, let me skip that for a minute. So for the candidacy prohibition, it established a different element of coverage in that only if your salary is 100% federally funded are you subject to the candidacy prohibition. And people will call the office and seek advisory opinions, and they'll indicate that 50% of their salary is covered by the Hatch Act, and so they're concerned that they can't run for partisan office. And the law is very clear. Your salary has to be 100% federally funded in order for it to serve as a bar to running for office, okay? Even if your salary only was 2% or 99% federally funded, that would still not be enough. It needs to be 100%. As to the remaining other prohibitions, the use of official authority and what we call the coercion provisions, that still requires an analysis of whether you have duties in connection with a federally funded program. And I'll go into more detail in a minute on that. So if you're covered, it applies to you even if you're on leave, leave without pay, sick leave, a furlough. You're still considered an employee for purposes of the Hatch Act. So I often have deputy sheriffs, for example, or folks from police departments that are covered and want to run for public office, and they say, well, can I take a leave of absence? And the answer is no. If as long as you remain employed, even if you're on leave and it's unpaid leave, you're still subject to the rules. Now, one key area, because sometimes people will file complaints involving judicial branch employees or legislative branch employees, and it's only executive branch employees that are covered by the Hatch Act. So as I said earlier, in terms of the use of official authority prohibitions and the coercion, the standard for determining whether you're covered or not is whether, A, you're employed by a state or local agency in the executive branch, and your principal employment is in connection with a federally funded program. And federal funds can both be loans or grants. So typically, when we get a request for an advisory opinion from someone in a sheriff's office or a police department, we will work with that individual to figure out, it's usually pretty evident that they're employed in an executive branch agency. The question becomes, do they have duties in connection with a federally funded program? And one of the key things here is many times people think that it's someone that has to be in a supervisory position or someone that administers the federal program. But the statute is clear in the case law that it's any duty in connection with a federally funded program. So as the slide indicates, we look at equipment costs, we look at administrative costs, operating costs, when we're looking to see where the federal funds are going in a department and who has contact with those federal funds. And for purposes of duties in connection with, it's not necessary that the individual's salary be federally funded. So even if someone's salary is wholly funded by the county, they're still subject to the Hatch Act if they have duties in connection with a federally funded program. And that can even include, for example, overtime programs. As I said earlier, you don't have to have any administrative or executive discretion over the federal funds or even decide how the funds are used. And this used to come up a lot, so I guess it's worth mentioning. Often people would say there was like a 50% rule, that it was only if a program received at least 50% of its funds from a federal grant or loan that program would then subject the individuals to coverage. That is not the case. It can be as small as a 10% that a program is federally funded. So in terms, and where I really wanted to spend the majority of the time is actually discussing the prohibitions, because that's where we get the majority of questions. And the first prohibition, assuming that you have duties in connection with a federally funded program, is that all employees that are subject to the law are prohibited from using their official authority or influence to interfere with the results of an election. And so there are a lot of things that fold under this prohibition. The first is any issues involving subordinates. And that is the majority of the cases that we get from sheriff's offices and police departments arise from allegations of political coercion where subordinates are being directed, advised, requested to vote a certain way or to support a particular candidate. And in terms of the Hatch Act, no magic words are necessary in order for the activity to be viewed as coercive. The case law finds that the relationship between a supervisor and a subordinate is inherently coercive. So even suggesting to someone that they attend a political event, even though you're not requiring it, would be prohibited under the Hatch Act. And let me give you a couple of examples of cases that we've had. So we've had recently, thankfully not in Virginia, but we've had a number of cases where subordinates were being asked to support either, these are cases either where the current sheriff was running for re-election or where the current sheriff was retiring and there was apparently like an heir apparent that folks were being asked to support. And the allegations included the keeping of lists, recording those individuals that were making campaign donations to the candidate of choice. The lists, as we understand from some of these allegations, are then used in terms of determining who will get promotions. Folks that were not on the lists were demoted. In one particular case where this was happening, there was also a very serious allegation that there was a department store where some of the folks there that owned the store were supporting a different candidate than the one the sheriff's office was supporting, and the allegation was that that some of the officials at that department basically said they were going to withhold law enforcement services and the assistance they were providing to this business owner if the business owner didn't support a particular candidate. As I can see from some of the expressions on your face, clearly a violation of the Hatch Act and probably even some other laws and regulations depending on the state. You may be wondering what happened in that case. I say unfortunately because I think it would have been a great case to take to the Merit Systems Protection Board where we take these cases. But in this instance, the individuals involved resigned and or retired from their positions, and therefore we did not have jurisdiction nor the board to pursue that case. But I can tell you that we had completed our investigation and it looked like a case that we would have moved forward and pursued vigorously if the individuals were still holding their positions. We've also had cases involving coercion, and some of these examples stem from federal cases, but would apply just as well to your departments. We had a case involving a supervisor who, during a staff meeting, indicated to his staff that he was a lifelong Republican, but for the first time in his life, he was going to vote for a Democrat. He then gave all his reasons. This was back in 2008. He then gave his reasons for voting for then candidate Obama, and then asked the staff to raise their hands if they were planning to vote for Obama. and then pointed to those individuals that did not raise their hand and asked them to explain why they were not voting for Obama. Clearly, you don't even need a law to know that that's wrong. We had a series of calls came into the office after that meeting, and we quickly investigated that case and filed a complaint with the Merit Systems Protection Board. It's clearly a prohibited use of official authority. When we asked the subject, he didn't deny doing it. He just explained that he always liked to have icebreakers before his staff meetings, and that this was no different than polling his staff about who they thought was going to win Survivor. We clearly disagreed with this individual and filed the disciplinary action complaint, and we were able to settle the case. He agreed to leave federal service and agreed to a permanent debarment from returning to federal service. The other case that I will share with you also arose in the context of a federal agency, but again would be applicable, and some of the facts are similar to what we've seen at the state and local level. We had a very high-level official who promised a subordinate that if she made a contribution to, he was setting up a PAC to help reelect President Obama back in 2012. And he told her that if she made a contribution of $2,000, he would help promote her into the career senior executive service ranks. She did not follow through and just stayed quiet and didn't do anything. He pursued these requests, called her at home. Then came her performance appraisal time, and he gave her a glowing performance appraisal. During that period of time, he also gave her a bonus to go along with the glowing performance appraisal. And as you can probably guess, the amount of the bonus was $2,000. And he was so bold as to tell her, as he was giving her the bonus, that now she had the money to make the contribution to the reelection effort. The reason she came forward, and you can understand how difficult some of these coercion cases are, because if you report the boss, given the facts and there's no one else that's involved in what's going on, then the boss immediately knows that it's you that's reported, him or her. In this case, she came forward because he came to her one evening while she was still in the office and showed her a check and indicated that someone else in the office had made the contribution, so it was now her turn. So she came forward, she filed a complaint with our office, and we have an arrangement with the Department of Justice that if we have a reasonable belief that a crime has occurred, we call them and have them review the case. And we did in this case because there's a federal law, a criminal provision that prohibits solicitation in the federal workplace. And clearly this individual was soliciting at least one employee at work for political contributions. The Department of Justice took this case and they took it before a grand jury, and unfortunately they were not able to secure an indictment. So the case came back to us and we decided to take a crack at it. So we investigated the case and we got very lucky. As we were investigating, someone in the general counsel's office found out about the investigation and came forward to testify that during an agency event, this individual had also been approached by the subject and asked to contribute $2,000 to this reelection effort. So we filed a complaint with the Merit Systems Protection Board, and this person as well left federal service. So that tends to happen in a lot of our cases that are serious. Once the individual sees that we file a complaint, most tend to retire or resign. And we usually get it in writing in terms of a settlement so that it ensures that the person can't come back or can't come back for a long time. Still talking about use of official authority, in these cases, almost all stem from complaints that we've received in law enforcement offices. Besides the issue of subordinates, it's also the use of one's official title or position, which can include the use of uniform. And so we get a number of complaints. In fact, I would say right now we have about 30 complaints in the office concerning police departments or sheriff's offices, and the majority are cases involving the use of uniform for campaign purposes. So it could be that you've got folks that are supporting a candidate, and it doesn't necessarily have to be a candidate like for sheriff. It could be maybe supporting a mayor or a governor, and they appear in a campaign ad wearing their uniform from the sheriff's office, or a police officer that's wearing his uniform. That is prohibited under this provision. That's a use of official influence to interfere with the results of an election, okay? Now, occasionally, as we investigate a case, we find out that the candidate, especially at the mayoral level or the gubernatorial level, they use some sort of stock photograph. It's not that the deputies or the police officers volunteered to appear in the campaign ad. It's that the governor or the mayor maybe were interviewing people, they were doing their jobs in their official capacity and meeting with law enforcement officials. Someone from their office took the picture, and then when they were running for re-election, they decided to use those stock photographs. Clearly, that would not be a violation of the Hatch Act, right? But if you volunteer to be in a campaign ad and you're asked to wear your uniform, that's prohibited, okay? Same thing about appearing in a campaign ad and using your official title. You have no idea how many commercials I look at over the years, because people will file them and they've got a link to a video, and you'll see the officer endorsing a candidate, but you'll see the banner that says, Deputy Sheriff so-and-so or Police Officer so-and-so. Using the title in that manner is also prohibited. Now, there's an exception here, and that applies to sheriffs. Our office has taken the position, and there's an advisory opinion on our website, that the statute allows certain concessions for elected officials even if they're covered. So for example, the statute makes clear that an elected official like a sheriff or a mayor or a governor, even if they were to be covered by the Hatch Act, they are still permitted to run for public office. So we've taken the position that given that they're holding not just a government position in terms of, like, for example, that I'm in the civil service, they're holding also an elected office. So by nature, they're wearing two hats, both an official and a political. We've taken the position that those elected officials, and it mostly applies to sheriffs, can, when they're running, for example, for re-election, appear in the campaign ad wearing their uniform, or that they can use their official title. Their official title can be in the re-election effort. Re-elect Sheriff, Jones. That would be permissible. But that only applies to elected officials, not to deputies that are seeking election for the first time or police officers. Another example that arises here has to do with signing endorsement letters. We receive complaints all the time about law enforcement officials that have signed endorsement letters showing their support for a candidate. And that is permissible, signing an endorsement letter that's going to be published, for example, in the newspaper, or it's going to appear on a candidate's campaign website. That is permissible as long as you're doing it in your personal capacity. It goes back to the question, are you using your official title or not? If you're signing as Sergeant, Smith, that's going to be a problem. But if you're just signing as Scott Smith, that's fine. So you need to make sure it's in your personal capacity. The other issue that we've had here with endorsement letters is that from time to time we get allegations that officers were required to sign the letter. And again, that would go back to political coercion. That would be prohibited. Certainly, if someone on their own wants to do so, they can sign an endorsement letter, but being asked by someone higher up in the chain of command to sign a letter would be prohibited by the Hatch Act. Another area that comes up in here, it has to do with the use of agency resources. We've had occasion where police departments or sheriff's offices have used an agency website to advertise someone's candidacy, whether it's a police chief that's running for sheriff, or whether it's even a sheriff, right, in that sheriff's office that's running for re-election. That office's website is not a campaign website. So there needs to be a separation between the campaign website and the official website, because again, the act is concerned with making it seem that the agency, right, the governmental agency is supporting a particular candidate. So that's why there needs to be a separation in terms of those types of announcements not happening from an agency website. Similarly, we've had complaints involving offices that are distributing campaign materials out of a sheriff's office or a police department. Again, prohibited. Those offices aren't campaign headquarters. So that's something that everyone also needs to be careful with. Any questions here? You guys are a particularly quiet audience. I normally generate a lot of hands raised during this part of the presentation. Any questions?
You'll get them.
Yeah.
Use the microphone, please, so we can all hear the questions.
Hi, I know you talked about federal loans and grants.
Yeah.
What about federal payments for services like holding of federal, like many of us will hold like U.S. Marshals prisoners? Is that something that would qualify us for the Hatch Act?
Typically, yes. We have several cases over the years where we've concluded, after looking at the agreement between the U.S. Marshals and the Sheriff's Office, that it constitutes a grant for purposes of the Hatch Act. So we approach these things, though, because sometimes the language can change in the agreement. So we always look at them, on a fact-specific basis, but generally speaking, we have concluded that those payments are grants for purposes of the Hatch Act.
My second question is, on social media, if individuals in the Sheriff's Office, especially higher up in the ranks, are sharing campaign-related messaging on their personal pages, but they are identified on those pages as working for the Sheriff's Office or an agency covered by this, would that be considered an issue?
So I'm going to say it depends. You said social media. So we have advised, we have extensive social media guidance that we've put out. It's on our website. And we've said that if someone just merely fills out their profile on their personal social media account, in particular, let's say Facebook, okay? And you indicate, your position, where you work. We've said that merely filling out that profile is not a use of official authority while engaged in political activity. Even if somewhere else on that account you express your views on political matters, okay? What would be a violation is if where you're stating your preference, let's say for a candidate, you then throw the weight of your office behind that endorsement and say, you know, because I'm so-and-so, I've worked with this individual for 25 years, you know, he was my captain, right? Now you're using your position to endorse that individual. But if you're just merely filled out your profile, there's not enough of a nexus. The only caveat that I have here has to do with LinkedIn. There's an issue with LinkedIn in that when you fill out your information, that information then travels with you to any statement that you post. So it makes it appear that you're actually in your official capacity, you know, making these statements. So we advise individuals to be very careful in terms of LinkedIn and probably not engaging in political activity on LinkedIn to avoid that situation, okay? I saw, I think, another hand. Did I answer? Yes.
Thank you. I've got a neighboring sheriff. This is just a situation I'm asking. Thank goodness my election is 2.5 years away. But if I'm supporting, showing my support to a sheriff that I've worked with, go stand with him while he's making his announcement. And at the time, not knowing that he even has an opponent at that point, nobody has actually officially announced. Is that against the Hatch Act that I'm up there supporting him if I'm in my uniform?
Yes, I would advise against if you are going to stand by someone that's announcing their candidacy, that you not be wearing. Now, are you a sheriff?
Yes.
Oh, okay, so that's different. So that's why I'm glad I asked. Like I said earlier, with sheriffs, because they're holding elective office, we've taken the position that the use of title or even wearing their uniform while endorsing or showing their support for another candidate is permissible.
Okay.
So you would be permitted to do that. Now, let me just make one other statement about sheriffs. The one warning that I would give here is that one thing is to appear in a campaign ad as the sheriff wearing your uniform, or to sign an endorsement letter and you sign as sheriff. What we have advised against that would fall back into the use of official authority is if, for example, you were going door to door in uniform, seeking support for a candidate. We would find that that's coercive because, let's face it, most people see a uniformed officer at someone's door, you're going to open the door, right? So we've advised that circumstances like that, in terms of one-on-one with citizens, that you not wear that uniform if you're going to be advocating for your own election or someone else's. Same, we would advise against it. It shows the official insignia or logo of your department. Yeah, we would advise against it. Okay, if you're going door to door. Okay. Or or for your own re-election effort. Door to door, we advise that you not do it because of, you know, there's the uniform. That symbol is very powerful, right? So citizens are going to feel compelled to open the door. I know I would, right? So we advise that even if you're the sheriff, if you're running for re-election, you should not go door to door wearing that uniform or your badge or official insignia, okay? The other thing that we've seen in this area is the use of vehicles. Let's talk about the use of vehicles and motorcycles, okay? So if it's a regular town parade, let's say it's a July the 4th parade, and the department always participates, the Hatch Act would not prohibit the sheriff and the department from participating, even if the sheriff is running for re-election. You have no idea how many complaints we get about this. What would be a problem is if during the parade there's distribution, right, of campaign material, right? Or if people are holding signs that say elect or re-elect, right? You're all there in your official capacity. It's not a campaign opportunity, okay? Now, speaking about parades, we've also had complaints where it was a campaign parade and government vehicles were used for the parade. That would also be a violation of the use of official authority, okay? Any questions about that?
I have a
Yes.
question about that. Suppose it's a parade and the sheriff normally participates in the parade in, the department vehicle. However, their personal vehicle is also in the parade with, say, election signs, re-elect whomever. Is that acceptable?
Okay, so this is a regular town parade, and you've got two groups. You've got
Correct.
the office, the sheriff's office, and then somewhere else along the
back-
parade
along the
route,
parade
you've got
route.
a campaign contingency.
Right.
Okay, so I've seen a video of this, not Virginia again, so this is good. It's Tennessee, a lot of cases from Tennessee. So here's the situation. We thought the case that I'm thinking about that I saw the video was a close call. Here's why. You had the sheriff's office, and right behind the sheriff's office, you had the campaign people, right? And both sort of bled together. So you had some of the uniformed personnel sort of falling back into the campaign folks and vice versa. We would advise against it, okay? So the answer is yes, you can do it, but I would put some distance between your campaign folks and the official representation of the sheriff's office, okay?
So, and also along those lines, I remember several years ago, someone came and talked to us about the Hatch Act, and they talked about the fact that as elected sheriffs, we could use our office vehicle to campaign in. Now, that's what was said years ago.
I'm
I'm just trying to find out if, I
Yeah,
mean, I wouldn't do it, but it's a,
so
Prudent to do.
my advice is,
no?
and I've been the chief of this unit now since 2000. So it must have been one of my subordinates that came. I would advise against using the vehicle to campaign. What we've said, and maybe this is just a disconnect, what we've said is that if you're permitted, and this even applies to, let's say, a deputy sheriff, if your rules allow for the personal use of your vehicle, then, for example, showing up to a campaign event, let's say that you're going to have a meet and greet at a location at a hotel, or it's a fundraiser at a hotel, and the officer drives that vehicle to that event, that would not be a Hatch Act violation, okay? But that's assuming, by the way, that your rules also permit what we view as personal use of that vehicle. But using the vehicle, even if you're the sheriff, for a campaign parade, for example, that would be prohibited. We've also seen sheriff's offices and police departments use the government vehicle as a fundraising tool. So they'll give people in the community a ride for a certain amount. If you contribute $100, you get to ride. Exactly. So I can't make these facts up. So that would be prohibited as well. In Tennessee. Sorry, Tennessee, I know I'm being recorded.
Just for
Yes.
clarification, earlier you said that let's say the sheriff is retiring, someone in his office has the desire to be sheriff, they cannot take a leave of absence and campaign because they're still considered a government employee?
So a couple of things. Deputy sheriff, right? Someone in the sheriff's office that now wants to run.
Correct.
First step is, are they 100% federally funded? If they're not, they can run and they don't have to step down. In the past, you would have had to resign.
Okay.
in order to run. The issue, though, is that even though their salary is not, and most officers, their salary is not 100% federally funded. So that's why now so many more officers can run. The question is going to be, are you still subject to this prohibition, the use of official authority? This is where we get a lot of complaints. So folks can run, they're still employed and working, and of course you can see how easy it is to fall into the trap of using your uniform, using your title to further your candidacy, okay?
So let's say that individual is going to run, sheriff's supporting them. The individual gets approached by a citizen and they're in uniform. What do they just say? I cannot talk to you about it? Or that's a difficult situation.
Absolutely.
They didn't initiate it and someone else does.
Correct. Bright line, though, I would advise against it. I would advise against it. You have no idea how many complaints we receive of people overhearing or seeing something. So in fact, we have a complaint right now of someone that was seeking to run for sheriff. This is a deputy sheriff, and he went to a diner. And at the diner, it's a small town, a lot of folks know this individual. He's in uniform, and the allegation is that he was there campaigning. I'm not so sure that he was there campaigning, but people were shaking his hand, he was talking to folks, so we're starting to interview witnesses. So my advice would be very careful. If someone wants to engage you in a discussion about your candidacy and you're in uniform, I would tell the individual, I know it's a hard call, but let them know you're on duty and maybe suggest a different time that you're off the clock that you can meet with them and talk about your campaign.
But if you had like 5 different sheriffs endorsing another sheriff, that would be no problem because they're all sheriffs.
Because they're all sheriffs.
That's right.
Yeah. Yes.
Does the Hatch Act apply to federal government contract employees?
The answer is no. If you're an independent contractor, for example, let's say working for Lockheed Martin, and you're assigned to the Department of Defense, that individual is not subject to the Hatch Act. There are some individuals under personal service contracts that may be subject to the Hatch Act. We've concluded that some of those folks are, but we have to look at it on a case-by-case basis because it depends on the language of the statute authorizing the agency to hire personal service contracts. Some statutes specifically indicate that the Hatch Act does not apply. But if the statute is silent, we've taken the position that those personal service contract employees are covered. But the majority of contractors are independent contractors, right? They're working for a third party. Those are not subject to the Hatch Act.
What if you are the elected official and you are asked to participate in a candidate's forum as far as wearing your uniform in that capacity?
Can you repeat the end of that?
If you are the elected official and
Yeah.
you are asked to be a part of a candidate's forum, wearing your uniform in that capacity?
Yeah, we've said that's okay as long as you're an elected official, okay? Now, let's talk about those of you that are not elected officials or some of the subordinates that you have.
Stand up. She couldn't see
I'm
me.
sorry. Oh,
That's
sorry
all right. You
about
couldn't
that.
see.
Sorry.
Hey, I'm standing up.
Sorry. I was
Hey,
looking
here
up.
we go.
We need to put a box in there.
Huh?
We need to get a box in Tony's stand up.
I see you now.
We love Tony Lippa.
Oh, Lenny, I'll be right with you, buddy. I'll be over there. I'm kind of confused that when you say that a person that's going to follow the sheriff that's in there and the people come to talk to them, they're not campaigning. My deputy or major or whoever is not campaigning. And if he doesn't talk to the people, they would say, well, he's rude. I asked him a question. And now the other thing that I'm going to fall in line with
Sure.
is you said you can't take annual leave or comp time, or can you do that?
Okay, so let's do the leave first. So you can take annual leave, you just don't have to. If you're not covered by the candidacy prohibition, right? Then the law permits you, since 2012, to run and still retain your position. In the past, you would have been required to resign because even taking leave would have not been sufficient, right? So on the off chance that there is someone in a police department or a sheriff's office, right, that is 100% federally funded, that's why I have the slide there, because even taking leave would not remove them from the candidacy restriction. But for the most part, I don't think anyone in a sheriff's office has to worry about that. I've not come across someone that's 100% federally funded. So if you want to take leave, that's fine, but you're not required to, because you can run. Now, your second question has to do with an officer that's running and someone comes up and wants to talk to them about the campaign. I'm certainly not suggesting that folks be rude, but the bottom line is, if you are if you are performing your official duties, that is not the time to be campaigning. So you can certainly talk to the individual. You don't have to be rude, but you need to explain to that citizen that this is not the time to be talking about the campaign, but you can suggest a different time. But you can't blend the two, because then you're in the use of official authority. You're in uniform, you're performing your official duties, and now you're also advocating for yourself. That would be prohibited. I know it's tough.
Even though you didn't initiate it?
Even though you didn't initiate it. Yes.
I don't want to beat a dead horse, but does the First Amendment just go out the window with a person in that particular situation? I mean, I can't be there to monitor that person 24 hours a day.
Correct.
Part of their job is to have interpersonal contact with the community.
Correct.
And part of that interpersonal contact is to talk about whatever the affairs of the community are, which might be an election. So I guess my point is, I would have to respectfully disagree that I think the person has the constitutional right to actually have a conversation with a person that lives in their community.
Correct. And I'm not saying they can't have the conversation.
Even if it's about their election.
I'm just saying that it can't be about advocating for their election. And yes, the Hatch Act is a restriction on the First Amendment. And it's been upheld 3 times by the Supreme Court. So it is a restriction on speech. And it's not a complete bar. That's why I'm saying it's just that when you're on duty, you're not campaigning. So that's the bright line, okay? And I know there's disagreement, but I want to make sure you all know the rules so you can avoid getting complaints, okay? The next thing.
Good morning.
Oh, sure.
Quick question.
Yeah.
We hear a lot about what we can't do.
Yeah.
What can your employees, if you're an elected official,
Sure.
and they want to support you, but you just certainly don't do that in the office, what can they do that does not violate the Hatch Act?
Okay. I'm going to get to that in a minute.
Thank you.
And in fact, I was going to go to a do, but this again applies to anyone that's running for office. But I'll get to your question in a moment. So, as you've seen, the sheriffs and other elected officials have a concession there in terms of use of title and uniform that others don't. Okay, but I also want to make clear that if you're, for example, a deputy sheriff or a police officer and you're running for elective office, you are not barred from having information on your resume, on your candidate profile that talks about your qualifications, right? So it's not that you can't, on your campaign website, indicate what your background is, your successes, if you've received awards as part of your time as a law enforcement officer, okay? But what we're advising is that you can't, for example, have a campaign ad that says, vote for Deputy Sheriff John Smith. That would be the use of official authority. But if, as part of your biographical information, you highlight your successes as a law enforcement officer, that is permissible, okay? Let me move, because I want to get to your question, sir. Okay, so the next prohibition, and we've talked about it, sort of already weaved in to this discussion, is that it's a lengthy statute, but basically we call it political coercion as well. And that is that you cannot directly or indirectly coerce, attempt to coerce, command, advise another state or local officer or employee to pay, lend, or contribute anything of value to a party, a committee, organization, agency, or person for political purposes. Basically, this also touches on the concern with subordinates. You can't advise, suggest, direct a subordinate to make a political contribution, whether it's monetary or even for volunteer services, okay? That doesn't mean that the subordinate, going to the gentleman's question, can't volunteer for your campaign because he believes in you and wants to see you get reelected, okay? So let me jump to that for a moment. Okay, so what can officers in your departments do? They can certainly attend political rallies and meetings. They can join and be active members of political parties. They can sign a nominating petition on behalf of a candidate. They can even circulate the nominating petition on behalf of a candidate. They can volunteer to work a candidate's campaign. Of course, none of these activities should be happening on duty or within the department. So even, for example, the signing of a nominating petition and the circulating of that petition, it can't happen in the department. It has to happen outside, okay? You can make campaign speeches on behalf of a candidate. Again, in your personal capacity, it's the same thing as signing endorsement letters. All of this has to be in your personal capacity unless you're the sheriff. Distributing campaign literature on behalf of a candidate, appearing in campaign ads as I indicated, but again, all in your personal capacity. Can't be wearing uniform, can't be using title. And of course, you can all run for public office in nonpartisan races. In fact, the Hatch Act doesn't apply at all if the election is nonpartisan. Let me go back here a minute.
You got a question?
Oh, yes.
Could I ask a question?
Sure.
You're talking, thank you. You're talking about partisan elections. If you have two people running, both as independents, that is not a partisan election.
That is correct. If you've got two candidates in the race and they're both running as independents, that's not a partisan race. But if you have one Republican or one Democrat or a Green Party person jump in, it becomes partisan. But if it's all independents, nonpartisan, and then none of these rules apply.
Could I follow up? It's a different subject. I guess the first thing I needed to find out is if there's a forgiveness factor in this Hatch Act, because
The what factor?
a forgiveness factor.
The forgiveness factor.
Because I'll give you an
15%.
example. I'm the sheriff in Tennessee of a small county. And I am not running for re-election, and I wrote a letter to my employees stating that I was not going to run again, and but I was endorsing my major. This was an inter-office memo.
Yeah.
How much time am I going to
The Norfolk jail has room.
And also, just another part of that, when I ran for office the first time, I had like 25 people who really, really helped me financially, I mean, who went above and beyond. I also wrote them a letter telling them that I wanted to give them advance notice that I was not going to run for reelection, but I am supporting my major, and I mail those things out. So I'm just wondering if I am
Sure.
need to move to Tennessee.
So I appreciate, so I appreciate your candor. So the second letter is likely, I don't know all the facts, but it doesn't sound like the second letter went to subordinates. So the second letter is probably fine. The first letter falls into some of the examples that I've been talking about, that if you're, if you're sheriff, a captain, you cannot advise, suggest to subordinates how they should vote. And so that includes Yep. I believe you. I believe you. However, in terms of the case law, like I said, because the relationship is inherently coercive between supervisor and subordinate, even though you didn't suggest the fact that you showed who you were endorsing and it was through inter-office mail, has all the indicia of being inherently coercive. So my advice would be that that's not something that should be happening.
He can take it back.
And no, that's fine. And in fact, he talked about the forgiveness factor. So I don't know that I'd call it the forgiveness factor, but we issue a lot of warning letters. It's only the most serious violations that we take to the Merit Systems Protection Board. So for what it's worth, we try to work with departments. We're very Hatch Act heavy in DC, right? Federal agencies, it's part of the culture. And federal employees are constantly being trained and warned about the Hatch Act. We find that once you move outside of the Beltway, even for federal employees, there's less and less awareness of the Hatch Act. So we try to work with departments and subjects, and that's why we issue a lot of warning letters, okay?
All right, so somebody in a ranking position, if a deputy wanted to send out an email blast to the rest of the agency saying, hey, sheriff's going to have a campaign rally at Sam's on Monday the 6th at 5 o'clock, is that a violation?
He's a deputy sheriff. He's not supervising anyone. That is not a violation. Now, let me give you the now. Occasionally, and this is only on occasion, we'll have someone higher up. The allegation is that that deputy was directed by someone higher up to send the blast. That would be a problem for the higher up, right? But if the deputy sheriff on his own decided, hey, I want others to know about this event, that would not be a violation. Okay?
I see John looking at his watch, so I'm going to hurry up.
I see it.
If the last two questions asked, even though it's
Yes.
a nonpartisan, is that still a violation?
No, if it's a nonpartisan race, the Hatch Act doesn't apply at all. So none of the rules we're discussing would apply if the race is nonpartisan.
All right, one more question on
Sure.
that. We talked about, when your first question, we talked about if you're going to support a sheriff, a reelection, but it's a police chief is going to stand up and support him, even though it's nonpartisan, is he not violating also?
So, can you repeat that again? I'm sorry.
All
So
right,
you have
you
a
got,
police chief?
let's say you got a panel behind the sheriff that's
Yeah.
getting ready to announce.
Yeah.
And you got a panel of 3 or 4 sheriffs and a couple of police chiefs.
Yes,
Is those-
and they're all in uniform,
Yes. The police chief, are they violating?
and the election is nonpartisan?
Nonpartisan.
Not violating the Hatch Act. There could be some other local rules that apply to the use of uniform, but it would not be a Hatch Act violation. The Hatch Act does not apply in any way, shape, or form if the election is nonpartisan, okay? So very quickly, I've talked about the Merit Systems Protection Board. That is where we take the most serious cases. So these are cases sometimes where you've been warned, you got that warning letter, right? And despite the warning letter, you've gone ahead and done it again. These are the cases that we're going to take to the Merit Systems Protection Board. The only penalty for violating the Hatch Act with respect to state and local employees is removal from office, okay? So if we take a case and the judge agrees that there's a violation, the judge has to make a decision. There's a violation, does it warrant removal? And if the answer is yes, that's the only penalty available. What happens next, if the person's ordered removed, is that the state or local agency has to decide, they have 30 days to comply with the notice from the board that there's been a violation and that it warrants removal. If the state or local agency declines to remove the individual, then the state or local agency forfeits federal money equivalent to 2 years' salary of the subject. So if the subject made $100,000, the federal agency forfeits, the state or local agency forfeits $200,000, okay? So at the end of the day, the agency always gets to decide whether the individual's gonna get removed or not, okay? Always with removal comes debarment. So if someone is removed, a state or local employee is removed from office, they are barred from coming back to state or local employment for 18 months. And if you have any questions that I did not answer or in the future you have questions, that's our contact information. I or my deputy respond to all the inquiries that come in on hatchact@osc.gov. That's where we get a lot of email advisory requests, and either I or my deputy respond to them. And then you can see that I've also got the hotline listed there. Emails we respond to within 5 business days, the hotline within 24 hours, okay? I'm gonna be around for a few minutes if anybody has any additional questions, but thank you for being such a gracious audience.
I've got a question.
You?
Ma'am, so if you
yes.
do, I mean, it's political season, so
Yep.
those complaints may be more prevalent in a political season. Does the person that's the subject of the complaint get to respond if there is some kind of a complaint that's forwarded?
Absolutely. Any complaint that we receive, unless, for example, the allegation is something that's not covered by the Hatch Act, right? So if it's something that we know we have no jurisdiction, we're not gonna call anybody, we're gonna close it out and send a letter to the individual letting them know that there was this allegation, but it's not covered by the Hatch Act. But if it's a matter covered by the Hatch Act, our first step is to figure out if the person's covered. Because again, on its face, we don't know if a state or local employee is covered unless they have duties in connection with. So we will call the subject to let them know we're gonna be asking their agency for information about whether they have any duties in connection with a federally funded program. So that's step 1. If we establish jurisdiction, then we will interview witnesses as well as the subject before making any decision about whether the Hatch Act was violated or not, okay? So you always get an opportunity to respond if you're a subject. Thank you very much.
Hey, you were great.
Thank you.
I'm getting texts up here from the audience.
Oh.
Saying you were great.
Well, thank you.
That's great. We'll have you back.
Thank you.
Yes, thank you very much, Anna, and we'll got to take a
They
break
get any
now.
money
Be
at all
sure
with
to
that
thank
without
the
offering anything, they'll come.
Welfare Health
If they
Solutions for
supervise.
this next break, and
It
see you back
depends,
at
right?
10:30.
Because agency may get federal money, but not